Included in these factors is evidence of motive. Motive is the moving power which impels a person to do an act to achieve the desired result. While criminal intent is material in determining the criminal liability of an offender, motive is not material in determining the criminal liability of an offender. There may or may not be motive established in the commission of the crime. The moment the crime has been committed, regardless of motive, there is a conviction. However, there are, however, instances where motive becomes material in determining the criminal liability of an offender. First, when the act of the offender would result to various crimes. Second, when there is doubt on the identity of the offender. And lastly, when there are only circumstantial evidence on the part of the prosecution in proving the said crime. In these three instances, motive becomes material to determine the criminal liability of the offender. When the act of the offender would result to violent crimes. The accused killed the mayor, a person in authority, while the mayor was alighting from his car. Coming from church, the mayor was alighting from his car, going home. The mayor was killed by the accused. Here, the acts of the accused could either be murder or direct assault with murder. Since the act of the accused would result to violent crimes, either murder or direct assault with murder, you have to know the motive on the part of the offender. If the said offender killed the said mayor because of the mayor's past performance of his duty, then it is direct assault with murder. But if the said accused killed the mayor for a personal reason, then the crime committed is plain murder. So here, motive on the part of the said offender becomes material to determine the criminal liability of the said accused. Likewise, when the identity of the accused is doubtful. No one saw who killed the victim, but the accused said, or the victim said, that the person who killed him was Pedro. There are 5 Pedros in the place. Who among these Pedro has the motive to kill the victim? Motive becomes material. Or when the said prosecution, the state has only circumstantial evidence in order to prove the commission of the crime. There is no direct evidence. There is no eyewitness. No one saw who killed the victim. Here, motive becomes material in order to determine the person who is criminally liable. A defense against criminal intent is mistake of fact. Mistake of fact is the misapprehension of facts on the part of the person who caused injury to another. If the accused acted under mistake of fact, he is absolved of criminal liability. Mistake of fact negates criminal liability because the offender acted without criminal intent. So it is a defense against criminal intent. But for one to be absolved, to be exempted from criminal liability based on mistake of fact, the following elements must be present. First, that the act done would have been lawful and justifiable had the facts been as the accused believed them to be. Second, the intention of the offender in performing the act must be lawful. And lastly, the mistake must be without fault, negligence, or carelessness on the part of the offender. If these 3 elements are present in the commission of a crime, the offender is absolved of criminal liability based on mistake of fact. That the act done would have been lawful and justifiable had the facts been as the accused believed them to be. Had the facts been as the accused believed them to be, his act is justified under Article 11, justifying circumstances, or he is exempted from criminal liability under Article 12. Second element requires that this accused in doing the act must be ignited solely by a legitimate, valid, lawful intent. And lastly, the law requires the mistake must be without fault, negligence, or carelessness on the part of the offender. The said offender must have exercised diligence in ascertaining the true facts of the case. Therefore, based on the third element, mistake of fact is not a defense in culpable felony. mistake of fact can only be a defense in intentional felony. One cannot have acted with negligence, with carelessness, and at the same time invoke mistake of fact. X saw that his friend Y was waiting for a ride. And so he wanted to poke a joke on Y. And so what X did? X grabbed the pistol or the long firearm of his younger brother. It was a long firearm, a toy firearm, which resembles that of an Armalite, and he took it from his brother who was playing. And wanting to poke a joke at Y's friend who was waiting for a ride, he immediately, slowly, secretly went at the back of his friend, who at that time was busy texting, busy on the cell phone. And then X went at the back, and then thereafter pointed the long firearm at the head of the said person of Y. And X told Y in a different voice, "Huwag kang gagalaw, hold up ito. Ibigay mo ang cellphone mo." Y could see, he turned his eyes to the right without moving, and he could see that there was this long firearm pointed at the temple of his head. And the said X repeatedly stated that, "Huwag kang gagalaw, ibigay mo ang cellphone mo, kundi papasabugin ko ang bungo mo." So here at that precise moment, afraid, Y was about to give the cell phone, but as he was trying to give the said cell phone, he immediately used the cell phone in order to give a strong hit on the left eye of the said person of X. It was only then that he realized that it was his friend who was poking and joking. The said friend lost sight of the said eye. And so, Y was prosecuted for the crime of serious physical injuries. However, in order to be free of criminal liability, he invoked the defense of mistake of fact. Is there mistake of fact so as to free him, absolve him of criminal liability? First element, that the act done would have been lawful and justifiable had the facts been as the accused believed them to be. Had it been true that a long firearm was pointed at his head, and that he would not give the cell phone, the said man would fire, his act is justified. He was actually acting in defense of himself, in defense of his property. Second, the intention of the offender in performing the act must be lawful. His intention was to protect his life, to protect his property. Third element, the mistake must be without fault, negligence, carelessness on the part of the offender. There was fault, there was no negligence. Who would think that someone was playing a joke on him? A kind of joke wherein his life would be a threat. All the elements are present, therefore X cannot be held up. The said Y cannot be held criminally liable. The said friend who allegedly wanted to play a joke on hold up cannot be held criminally liable. But what if the police officers learned, or the police officers from over the radio got a tip that there was this kidnapping done. A woman, a rich Chinese woman, was kidnapped and boarded on a van. The van was colored green. That was the report on the PNP station. And based on the said report, the van would pass on the direction of the said PNP precinct. And so the police officers went out of the precinct and got ready themselves. They readied themselves. Minutes later, they saw a green van pass by, and they immediately fired at the said green van. After firing, about 5 police officers repeatedly fired at the said van. 2 people died inside, and 3 others went out waving white handkerchiefs. It was only then they realized that these men were not the kidnappers. These men were employees of Meralco. And so, the said police officers were charged with the crimes of 2 counts of murder and also 3 counts of attempted murder. They said they acted under mistake of fact because they got a report that there was this kidnapping that took place and the said kidnapped victim was placed on board a main van. Was there a mistake of fact? First element, that the act done would have been lawful and justifiable had the facts been as the accused believed them to be. The first element is immediately absent. Granting for the sake of argument that that van is where the said victim, the kidnapped victim, is placed or boarded, the police officer should not immediately fire. They could hit the said victim. They should verify first. Instead of immediately firing, the first element is immediately absent. The second element, the intention of the offender in performing the act must be lawful. The second element is absent. The fact that they repeatedly fired, the intention was to immediately kill those inside the van. Third element, the mistake must be without fault, negligence, carelessness on the part of the offender. There was fault, there was negligence, there was carelessness on the part of these police officers. As police officers, they should not have immediately fired. They should determine first the facts and the circumstances. All the elements being absent, the police officers cannot lie on mistake of fact for an appeal. They should be convicted as charged. There are certain crimes wherein criminal intent is immaterial. First, in case of culpable felonies. Second, in case of acts mala prohibita. Acts mala prohibita are those acts which are only wrong because there is a law that defines and punishes the said act. Question last bar, 2017 bar distinguish acts mala in se versus acts mala prohibita. This is again a favorite question. So the following are the distinctions between acts mala in se versus acts mala prohibita. First, acts mala in se are acts which are inherently evil or wrong. They are wrong per se, wrong by their very nature. Whereas acts mala prohibita are acts which are only wrong because there is a law that defines and punishes the said act. Second, in acts mala in se, the basis of criminal liability is the moral trait or intent on the part of the offender. Whereas, in case of acts mala prohibita, the basis of criminal liability is the actual performance of the prohibited act. Third distinction, in acts mala in se, good faith or lack of criminal intent is a valid defense. Whereas, in case of acts mala prohibita, good faith or lack of criminal intent is not a valid defense unless expressly provided by the law. Fourth, in case of acts mala in se, modifying circumstances such as mitigation and aggravating circumstances are not considered by the court in the imposition of penalties, whereas in case of acts mala prohibita, these modifying circumstances are not considered unless the law provides otherwise. Fifth distinction, in case of acts mala in se, the degree of participation of the offender, whether the offender is a principal, an accomplice, or an accessory, is considered by the court in the imposition of penalties, whereas in case of acts mala prohibita, there is no degree of participation considered by the court. All perpetrators are punished to the same extent. And lastly, in case of acts mala in se, the stage of the execution of the crime, whether the crime is committed in the attempted, frustrated, or consummated stage, is considered by the court in the imposition of penalties. Whereas in case of acts mala prohibita, there are no attempted and frustrated stages committed. It is only the consummated act that is punished by acts mala prohibita. So those are the distinctions, acts mala in se versus acts mala prohibita. An act malum in se cannot absorb acts mala prohibita, and vice versa. An act malum prohibitum cannot absorb acts mala in se. Reason is, what makes an act malum in se is the presence of intent or negligence on the part of the offender in doing the act. Whereas in case of malum prohibitum, what makes the act punishable is the presence of a special penal law that punishes the said act. Hence, one cannot absorb the other. Not all crimes punished by special penal laws are considered as acts mala primina, and not all crimes punished under the RPC are considered as acts mala insen. Under Article 220, the law punishes technical malversation. Under Article 220, the revised penal code punishes technical malversation. In the case of Isidoro versus People, the Supreme Court said, technical malversation, although punished by the RPC, is an act malum prohibitum. Good faith or lack of criminal intent is not a defense, because the very act of transferring the funds would be the consummation of the crime. Plunder is punished by special penal law. But in the case of Estrada versus Sandigan, by the Supreme Court said, plunder is malum in se, not malum prohibitum. Therefore, in cases of plunder, good faith or lack of criminal intent is a valid defense. The prosecution must prove the presence of criminal intent on the part of the offender. In the crime of plunder, Supreme Court said it is malum in se, not malum prohibitum, although it is punished by special penal law. Reason is, it is inherently evil or wrong to amass or accumulate ill-gotten wealth. The accused was charged with a crime of murder. The information alleged that the accused killed the victim by running over the victim with the use of his car. Since the said act of killing was done by means of a motor vehicle, under Article 248, it is murder. The killing qualified by use of motor vehicle. During the hearing of the case, the accused, when presented by the defense, testified that he lost control of his car. He lost control of the brakes of his car. He has no intention to kill the victim. In fact, he did not know the victim. It just so happened he lost control of the brakes of his car. The judge believed, and the judge convicted the accused of reckless imprudence resulting in homicide, although the information charges murder. Is the judge correct? The accused said, since the information charges him of murder, yet the judge convicted him of the crime of reckless imprudence resulting in homicide, this judge denied him of his right to be informed of the nature of the cause of accusation against him. Is this argument valid? The argument of the accused is not valid, the judge is correct. The judge is correct because reckless imprudence resulting in homicide, a culpable felony, is necessarily included in the intentional felony of murder. Hence, even if the crime charge is murder, killing, qualified by the use of a motor vehicle, if evidence show that there was no deliberate intent but the said act of killing was a product of negligence, the judge is correct in convicting the accused of reckless imprudence resulting in homicide. Under Article 4, criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended. Likewise, criminal liability shall be incurred by any person performing an act which would have been an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Under Article 4, these are the two means by which a person can also be held criminally liable. Under the first paragraph, criminal liability shall be incurred by any person committing a felony, although the wrongful act done be different from that which he intended. This is otherwise known as the proximate cause doctrine. The elements of Article 4, first paragraph are: first, the intended act is a felonious act. Second, the resulting act is a felony. Third, the resulting felony is the direct, natural, and logical consequence of the felonious act of the offender. Otherwise stated, the felonious act of the offender is the proximate cause of the resulting felony. So for one to be liable under the proximate cause doctrine, it is necessary that he was performing a felonious act. His intent was to commit a felony. And indeed, a felony resulted, even if that resulting felony is different from that which he intended. If the said resulting felony is the direct, natural, and logical consequence of his felonious act, he still becomes criminally liable. Proximate cause is the cause that sets into motion all other causes and which, unbroken by an efficient intervening cause, produces the felony without which the felony would not have been produced. Based on this definition of proximate cause, for one to be liable under the proximate cause doctrine, it is necessary that there is no efficient intervening cause that would have broken the causal connection between the felonious act and the resulting felony. The moment there is an efficient intervening cause, an efficient supervening cause, that would have broken the chain between the felonious act and the resulting felony, the offender will not become criminally liable for the resulting felony. An efficient intervening or supervening cause is an active force, which is a distinct act or fact absolutely foreign from the felonious act of the offender. It is necessary that totally it has nothing to do with the said act of the offender, with the felonious act of the offender. X was turned down by Y. X was courting Y, and so X was turned down by Y. He was mad at Y. For 6 months he courted Y. Yet he was turned down by Y. So, to get even with Y, they were schoolmates. He knew that Y would pass by every morning on this portion of the stairs at exactly this hour. And so what he did, he placed gasoline, oil, on the said stairs. And the moment Y passed by, Y slipped, fell on the said stairs. The head of Y hit the cemented pavement, and thereafter Y died. And so X was prosecuted for the crime of homicide under the proximate cause doctrine. X said he has no intention to kill the victim. Will his defense lie in his favor? X's defense would not lie in his favor. He has to be held criminally liable for the crime of homicide under the proximate cause doctrine. The intended act was a felonious act, pouring gasoline in the streets for the said woman to sleep. That is a felonious act. It resulted to a felony, homicide. Homicide was the direct, natural, and logical consequence of his felonious act. Therefore, X would be liable for homicide under the so-called proximate cause doctrine. X brought a prostitute in a motel. They checked in this hotel. In this hotel, X inserted on the said prostitute a rusty and oversized vibrator on the genitalia of the said prostitute. It was a rusty and oversized vibrator. The said prostitute started to bleed. Because of the profuse bleeding, X became so afraid, he left the prostitute. Here comes the boy in the said motel. They saw what happened to the woman. They brought the woman to the hospital, but the woman thereafter died. Too much blood had been lost, the woman died. What crime has been committed by the man? Is the man liable of any crime? The man is liable of homicide under the proximate cause doctrine. The felonious act of inserting an oversized rusty vibrator on the genitalia of the said woman is a felonious act. It resulted to a felony, that is, the death of the said woman. And this death, that is the homicide, is the direct, natural, and logical consequence of his felonious act. Therefore, he should be criminally liable for the crime of homicide. Mang Pedro was having siesta. While Mang Pedro was having siesta about 3 o'clock at the porch of their house, he was awakened because of the noise of some children. He went to the street to look where the noise was coming from until he realized the noise was coming at the background of his place. He went at the backyard of his place, and there he saw 3 young boys on top of his rambutan tree. They were harvesting the rambutan fruits. He was angry, and so he told the boy, "You come down from the tree. If you will not come down from the tree, I will call immediately the police and you will all be arrested." Afraid upon hearing the word police, these boys, between ages of 6 and 7, immediately ran down the tree. One of them, from the topmost portion of the tree, jumped. However, he fell wrongfully. The said head of the boy hit a big stone on the ground. And so the said boy died. Is Mang Pedro liable for the death of the said boy under the proximate cause doctrine? First element, the intended act is a felonious act. The first element is absent. The act of Mang Pedro saying, "You get down from my tree, otherwise I will call the police." It is a legitimate act, a valid act of a person whose property is being taken. These boys were taking these fruits without permission. That is a valid act. The intention of the offender was the intention. The second element requires that the said element, the intention of the offender is not unlawful here. He wanted to bring the boy to the police authorities because they were, in effect, committing the crime of theft. And this, since the said person was not committing a felony, therefore, Mang Pedro will not be criminally liable for the resulting felony even if it amounted to the death of the said young boy. So it is necessary, first and foremost, that the offender, the accused, must be committing a felonious act before he becomes criminally liable under the so-called proximate cause doctrine. If in the first place he is not committing a felonious act, then he cannot be criminally liable for any resulting felony. These two friends were having a drinking spree. After working overtime, before going home, they pass by this canteen and they have a drinking spree. And during their drinking spree, they were discussing politics. Of course, one is on the side of Duterte, the other one is on the side of the former administration. And both of them were throwing negative things at each other until both of them got pissed off because they had already taken liquor. And so in the course thereof, one of them, X, broke a bottle of beer and he used it to stab the stomach of his friend Y. Thereafter, after doing that, X immediately left. Y was on his way home. While Y was on his way home, suddenly, there was this gunfire. There was this police officer who was running amok, asking for anybody who would want him to fight, and he was firing shots in the air. And while Y was walking towards home, a stray bullet hit the head of Y. Y died. Because of his death, the heirs of Y filed a case of homicide against X under the proximate cause doctrine. They argued, were it not for the stab wound inflicted by X on his friend Y, Y would not have died. Is X, the friend, liable under the proximate cause doctrine for the death of Y? X is not liable under the proximate cause doctrine for the death of Y. X is only liable for physical injuries but not for the death of Y. The reason is that the said bullet that hit the head of Y is an efficient intervening cause that has broken the causal connection between X's felonious act of stabbing the victim and the resulting felony, which is the death of the victim. The said stray bullet is an active force which is a distinct act or fact, absolutely foreign from the said act of stabbing. Therefore here, because of that sufficient intervening cause, X would not be held criminally liable for the death of the said victim. While X was buying in the store, Y rushed towards X and then hit the left side of the body of X with a sharpened bamboo stick. After hitting X with a sharpened bamboo stick, Y hurriedly left. X was brought to the hospital. The wound would heal within a period of 5 days. It was only a slight wound, and he was allowed to go home that very night. However, 22 days thereafter, X was brought to the hospital. He was suffering from convulsion, and the doctor said he was suffering from tetanus poisoning. The following day, 23rd day, X died. Because of this, the heirs of X filed a case of homicide against Y. They argued, were it not for the stab wound, X would not sustain tetanus poisoning, X would not have died. Is X liable for the death of the said, is Y liable for the death of the said victim? The accused is not liable for the death of the said victim, but only for physical injuries. In the case of Urbano versus IA, and also in the case of People versus Villacorta, the Supreme Court said that it is settled that tetanus poisoning has an incubation period of 2 weeks or 14 days. Therefore, if the stab wound inflicted by the accused on the victim has severe tetanus germs, the victim would have died within a period of 2 weeks. But the victim suffered only tetanus poisoning on the 22nd day. Therefore, the wound inflicted by the accused on the victim has no tetanus germs. Supreme Court said, the victim performed acts that brought the tetanus germs on his wound. Therefore, the same is considered to be an efficient intervening cause that has broken the causal connection between the felonious act and the resulting family. If ever the accused is liable, the Supreme Court said it would only be physical injuries and not for the death of the said victim. Under Article 4, first paragraph, there are 3 instances wherein a person becomes criminally liable for the resulting felony, although different from that which he intended. First, we have the so-called aberracious or mistake in the blow. Then we have error in person or mistake in the identity. And then we have greater intention when the consequence went beyond the intention. These are the 3 situations wherein the offender becomes criminally liable for the resulting felony, although different from that which he intended. Aberracious or mistake in the blow is a situation wherein the offender directed the blow at the intended victim. But because of poor aim, the blow landed on another person. Because of lack of precision, the blow landed on another person. Here, both the intended victim and the actual victim are at the scene of the crime. Generally, an aberracious would result to 2 crimes. The first crime against the intended victim, and the second crime against the actual victim. If these 2 crimes happen to be grave felonies and less grave felonies, Article 48, complexity of crimes, comes in. So you have to complex it. But if one of the resulting felony happens to be a light felony, like slight physical injuries, you cannot complex it under Article 48, because under Article 48, you can only complex a grave or less grave felonies. The accused wanted to get a revenge on Y. Y tried to molest his sister while the sister was on the way home. And because of that, he wanted to get a revenge at Y. And so the accused tried to look for Y. Y was a tricycle driver. And finally, after looking at him for 2 hours, he found Y. along with the other tricycle drivers, waiting for a ride in the public market. And upon seeing Y on board his tricycle, he went on the other side of the street, on board his motorcycle. And there he saw that Y has two passengers inside the said tricycle, and one as a back rider. And so before Y would be able to leave, the said accused X fired at Y with intent to kill, hoping to kill Y to get a revenge for his act of trying to molest his daughter. However, X lacked precision. And so the bullet did not hit the said driver, his intended victim, but rather it hit the back rider, a passenger. The back rider, a passenger, died. What crime or crimes had been committed by X? First, insofar as the intended victim, the tricycle driver, is concerned, the crime committed is attempted murder. Insofar as the passenger is concerned, who was actually hit by the bullet and who died, the crime committed is murder. Both attempted murder and murder are grave felonies. Therefore, Article 48 comes in. The crime committed is murder with attempted murder. Insofar as the passenger is concerned, why not homicide? Isn't it that the treacherous act of killing only applies to the intended victim, the driver, and not to the said passenger? So it should be homicide. It is murder, it is not homicide. The Supreme Court, in the case of People versus Flora, and known as the Flora Doctrine, Supreme Court said that treachery that is present in the act of trying to kill the intended victim also applies on the actual victim. Therefore, the crime committed would be murder with attempted murder. But what if in the same problem, when X, the accused, fired at his intended victim, that is the tricycle driver, the said bullet did not hit the tricycle driver because of lack of precision on the part of Y. It hit the passenger, the back rider. The said passenger back rider sustained a fatal wound, a mortal wound. But because of immediate medical operation, the said passenger survived. What crime or crimes had been committed by X? Insofar as the intended victim is concerned, the crime committed is attempted murder. Insofar as the actual victim, the back rider, the passenger, is concerned, the crime committed is serious physical injuries. Why not frustrated homicide? Why not frustrated murder? It is not frustrated murder, it is not frustrated homicide, because insofar as the said passenger is concerned, there is no intent to kill. Therefore, it should only be serious physical injuries. But why is it that in the first problem, when the said passenger died, it is murder? Because there, since the victim died, intent to kill becomes a general criminal intent to kill. But here, the said victim survived despite the fatal wound. It is only serious physical injuries because insofar as he is concerned, X had no intent to kill. So the said act of X, firing, resulted to one grave felony, that is attempted murder, insofar as the intended victim is concerned, and serious physical injuries, a less grave felony, insofar as the actual victim is concerned. Therefore, Article 48 still comes in. The crime committed is attempted murder with serious physical injuries. But what if in the same problem, when X fired at the driver with intent to kill, hoping to kill the driver because of lack of precision, the bullet hit the passenger, the back rider, but he was only slightly hit on the arm. When brought to the hospital, the said wound would heal within a period of 3 days. What crime or crimes had been committed by X? Insofar as the driver is concerned, the intended victim, still it is attempted murder. Insofar as the passenger, the back rider, is concerned, the crime committed is slight physical injuries. Since one of the resulting felonies is only a light felony, you cannot complex it. Therefore, here, X will be charged of 2 crimes. One is attempted murder for the said intended victim, the tricycle driver. and the other one is slight physical injuries because of the injuries sustained by the actual victim. No complexity of crimes because one of the resulting felony happens to be a light felony only. The other situation under Article 4, first paragraph, wherein the offender becomes criminally liable for the resulting felony, although different from that which he intended, is known as mistake in the identity or error in personnel. It is a situation wherein the offender directed a blow at the victim, thinking that he was the intended victim. But the intended victim was not at the scene of the crime. Here, it is only the actual victim who was at the scene of the crime. The intended victim was absent, not at the scene of the crime. The actual victim was mistaken to be the intended victim by the said accused. Insofar as error in person is concerned, under Article 49, the law provides that if there is a variance between the intended felony and the felony actually committed, the penalty for the lesser felony shall be the one imposed. So based on Article 49, if the resulting felony would be of variance, the felony actually committed is different from the intended felony, under Article 49, error in personnel would be a mitigating circumstance. Because Article 49 mandates the lesser of the two penalties shall be the one imposed. But if there is no variance, there is no difference between the intended felony and the felony actually committed, error in personnel would have no effect on the criminal liability of the offender. It would not mitigate the criminal liability of the said offender. In the course of a fight, between X and Y, X boxed and kicked the victim Y. Y fell on the ground. When he fell on the ground, he could not immediately stand up. He was facing the ground. X felt he defeated Y, and so X hurriedly left the scene. Y, however, tried with all his might to stand up. He wanted to retaliate. He pulled out a Swiss knife, opened it, and stabbed the person next to him, thinking he was still X, the person who boxed him, but it happened to be his father who saw everything and who wanted to give him help. And so, Y stabbed his own father, and the father died. What crime has been committed by Y? Y would be liable for the crime of parricide. Y is liable for the crime of parricide because Y killed his own father. If you were the judge convicting Y of parricide, what penalty would you impose? The penalty for parricide is reclusion perpetua to death. Would you impose reclusion perpetua? If you were the judge convicting Y of the crime of parricide, you should not impose reclusion perpetua, the penalty prescribed for parricide. Reason is, there is a variance between the felony actually committed and the intended felony. The felony actually committed was parricide, but the intended felony was homicide. His intention was to kill X, the person who boxed him. Since there was a variance between the intended felony, homicide, and the resulting felony, parricide, Article 49 comes in, and under Article 49, the lesser penalty shall be the one imposed in its maximum period. Therefore, for having killed his father, Y shall be convicted of parricide, but the penalty to be imposed would be that of for homicide, reclusion temporal, in its maximum period, based on Article 49. But what if the daughter informed the father that his classmate, his schoolmate, tried to molest her? The father was so mad at the said schoolmate by the name of X. And so the father, very, very mad, went to the said school the following day. He was looking for X. He knew the face of X. X had gone to their home several times. And so the moment the father saw a man that exactly looked like X. The father immediately gave the said man a big punch on the face and on the stomach until the said man fell on the said ground. Thereafter, the father left. That man was not X. That man happened to be the twin brother of X, who exactly looked like X. And said twin brother, that is the victim, sustained a wound that would heal within a period of 30 days. And so the father was charged for less serious physical injuries. The defense of the father, he is not liable. He has no intention to injure this victim. His intention was to injure X. Since he has no intention to injure the victim, it was purely a product of mistake of identity. Therefore, he is not criminally liable. Will his defense lie in his favor? His defense would not lie in his favor. Mistake in the identity is not an absolutory cause. Mistake in the identity is not an exempting circumstance. Regardless of who the victim is, whether the intended victim or the actual victim, there is still criminal liability on the part of the said father. However, here the father committed the crime of less serious physical injuries on the actual victim. There is no variance between the crime that he committed on the actual victim and the crime that he intended to commit on the intended victim that was X. Therefore, here, Article 49 would not come in, the crime committed would be as is, and mistake in the identity will not mitigate the criminal liability of the said offender. What if the husband wanted to kill their neighbor? The husband was so mad at this woman neighbor, and he wanted to get even. And so because of that, he waited in ambush behind a tree for the arrival of the said woman neighbor. The woman neighbor, after conducting surveillance, he knew that she always passes by this dark portion of the street every 11 o'clock in the evening. And so he went behind a tree and waited for the arrival of the said woman neighbor. When a woman passed by, who looks exactly based on the shadow that of the woman neighbor, the said man got out of his hiding place and repeatedly stopped the said woman. When he took his flashlight and looked at the face of the woman, he realized it was his own wife. He stopped and killed his own wife. Of what crime should he be prosecuted? He should be prosecuted for the crime of parricide. He killed his own wife. Does Article 49 lie? And does Article 49 mitigate his criminal liability? Although there is a variance in the title of the crime, the actual crime committed is parricide, the crime intended to be committed is murder, since both of them have the same penalties, Article 49 would not come in. Article 49 will not mitigate the criminal liability of the said offender. Here, error in persona will not mitigate. Reason is the penalty for parricide is reclusion perpetua to death. The penalty for murder is also reclusion perpetua to death. Since there is no distinction as to the penalties between the actual crime committed and the crime intended to be committed, Article 49 will not apply. Here, error in persona is not a mitigating circumstance. The third instance under Article 4, first paragraph is known as praeter intentionem, when the consequence went beyond the intention. It is a situation wherein the offender directed the blow at his intended victim. However, the injurious result is far greater than what could be expected from the means employed by the offender. For praeter intentionem to apply, it is necessary that the following elements be present. First, that an intentional felony be committed. And second, that there is a notable disparity between the means employed by the offender and the resulting penalty. These two elements must be present. If these two elements are present, and there is praeter intentionem is always and always a mitigating circumstance. Because it is expressly provided for under Article 13 as a mitigating circumstance, that the offender has no intention to commit so grave a wrong as that committed. The